You said it's neither one of them.
Sir, you
Did you
better
not?
go back to law school because I don't think you got the education you need to represent yourself. All
Okay.
right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
'Cause I wanted to know the cause and nature of the what's bringing the suit against you. So I really didn't understand.
In the tense atmosphere of a Kansas courtroom, Judge Webster stares down a man who believes he can outwit the system armed only with internet myths and misplaced confidence. The defendant Isaiah walks in thinking he can challenge jurisdiction like it is some magic word that will make the charges vanish. The judge opens with the facts. You are accused of operating a motor vehicle without a valid license. The trial is set. The dates are firm, yet instead of answering, Isaiah begins with demands about cause and nature, repeating phrases he found online. The judge explains how Kansas law works, how legislators create rules for everyone to follow, and how driving without a license is a misdemeanor punishable by jail and fines. But Isaiah will not focus. He insists on speaking about common law and admiralty law, though he were sailing into court on a pirate ship. The courtroom watches as patience starts to thin.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would
Mhm.
that it gives the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through like either like common law or is it colorable maritime admiralty law? Which one am I want to be tried under? With jurisdiction?
The prosecutor, Ms. Gillette, steps forward with clarity. Jurisdiction is established by the Constitution of Kansas and the statutes passed by its legislature. She outlines the interstate compact, explaining that by driving in Kansas, Isaiah automatically consented to its laws. Yet Isaiah keeps pushing, asking if there was a form he signed, if this was maritime or common law. The judge repeats the answer again. This is criminal law under Kansas statutes. Isaiah appears unable to process it. He circles back to the same question over and over like a broken record. The judge warns him to file motions in writing so the court can respond, but Isaiah has nothing on file and nothing concrete to argue. Instead, his questions drift into the absurd, challenging legal basics as if the judge must pass his personal quiz before the trial can proceed.
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is
Admiralty.
correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under, so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime amnesty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
therefore, if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
The tension builds as the judge tries once more to give Isaiah an option. Do you want a jury trial? Do you want an attorney? Isaiah refuses to answer directly, insisting on more explanations of jurisdiction. He accuses the court of hiding some secret authority. He claims the Sixth Amendment gives him a right to understand the law before the trial. The judge reminds him it gives the right to be informed, not to receive a personal legal education. In court, Isaiah will not accept it. He repeats the same point until the judge begins warning of contempt. This back and forth drains precious time. The prosecutor points out he never filed for a jury trial, meaning it could default to a bench trial. Isaiah suddenly says he wants a jury, yet he is in Texas, far from Kansas, and clearly unprepared to be present.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case for the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion but not by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that be under? That would be civil? Would
Sir,
that be
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding, when you say, like, if you said the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law.
The judge tries to schedule a live pretrial hearing the next day. To move things forward, Isaiah objects, saying it is impossible to make the 14-hour drive from San Antonio. He insists he was told by an officer it could be handled remotely. The judge is firm this is an in-person trial, and the court will not be run by his convenience. She warns that if he fails to appear, a warrant will be issued. Isaiah argues the distance again, naming states between Texas and Kansas. The judge reminds him that his alleged offense happened in Kansas and that is where the trial will be. Isaiah claims confusion about the jurisdiction, once more prompting visible frustration from both judge and prosecutor. The court's patience is running on fumes.
So by now, you should have had all your motions on file. We're ready.
Yeah, maybe misunderstood what I was
please
asking.
don't interrupt to me.
I still had a question.
Sir,
when you're done.
stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Because I was going to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What do you intend to be tried with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, sir, there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now, that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, so it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. It froze.
I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully, know how to defend myself.
Okay, you don't like my ruling.
You don't. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I should know about?
Okay, sir. Here's the deal. You're either. I'm not going to play games with you. I understand the sovereign citizen position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking
how the right to defend myself
under my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer. And I'm like, before I even go to trial, I like to know what jurisdiction I'm falling up under. And you're telling me how to find, in order to find out, I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only only lawyers understand what jurisdiction or whatever I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment, do you not?
Judge Webster makes one last attempt to bring order. Isaiah is told if he represents himself, he will be held to the same standards as a trained attorney. He must know procedures, rules, and laws, he must file motions on time. Yet he insists on verbal sparring over legal terms. He does not understand the judge warns him to stop repeating the same questions or face contempt. Isaiah pushes again, asking if there was a harmed party, because in his mind criminal law requires. When the judge explains again that the law says otherwise, he refuses to listen, choosing to challenge. Instead of prepare, the pressure in the room is tangible like a storm ready to break over the defendant's stubborn stance.
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not
Yeah,
going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. And when I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me
I'm not
to?
arguing about the court. I'm trying to understand. I'm
If
still not
I
understanding.
I cannot educate you and train you
I'm not
on
asking
law.
for educate.
If you want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for
I'm-
court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So what are you going to do on the issue of attorney? Continue to.
I'm just simply asking you to identify the code of the written law that you're asking to do. I'm just asking you which code is that you're bringing against me as constitutional law. Because if that's a civil law,
taking up time. Can you not understand what I'm saying?
You're asking me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a
Before we
Zoom.
get to trial, I'm trying to figure out the jurisdiction. You just haven't went over to what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
I'm appearing in person right now. I'm doing my duty to appear, but you're not telling me.
We're not having a Zoom jury trial.
They're not telling me. You're not telling me you're not even telling me what the nature of the cause. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking, where's the injured party? Can you bring the injured party forward?
Mr. Kervin, you are set for jury trial.
But before we even get to trial, man, you still haven't answered my questions. I still want to know the cause of nature of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we get to jury trial. You're just setting it.
You are now found in contempt. We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions
Man,
about
I
what?
don't know. I still have questions that was never answered.
I'm not your attorney, sir. I'm your
Yeah, I
judge.
know you're not returning. I'm asking you, Judge, what is your I'm asking for legal bias. I asked you what was your legal intent. You still haven't told me what
My
you're going to ask you what was the nature and cause of this
my
for this
legal intent is to conduct a jury trial on you Wednesday with the jury.
and what
And
was the nature and cause of this whole before all that? What
the
was your nature and cause?
nature of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature.
Finally, the judge finds him in contempt and fines him $50. It is not about the money, it is about respect for the process. Isaiah keeps pushing, asking the same question, claiming it was never answered. The prosecutor clarifies the case law does not grant him an automatic jury trial because the maximum penalty is 6 months or less. The request still needs to be in writing. Isaiah says again he wants a jury, but offers no plan for how to attend from Texas. The judge notes the time, the resources, and the inconvenience he is causing. The court orders him to appear in person the next day at 1 p.m., warning that if he is not there, a warrant will issue. Isaiah protests about distance. Once more, the tension thickens, like the walls are closing in on him.
Now,
And you said
I'm
this,
not,
and I asked,
we're
I
not
have a
doing this.
question. I said a question. So when I asked you what jurisdiction, the Constitution grants the courts the two jurisdictions. Which one is common law, and the other one is
Sir,
maritime admiralty law. You said it's neither one of them.
sir, you
Did
better
not?
go back to law school because I don't think you got the education you need to represent yourself. You either need to go back to law
That's
school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if
I'm
you're
asking a
not
question,
here
Your
and
Honor.
ready to go, if you're not here and ready to go Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I
And
asked
I
you which
told
law
you,
the
sir, I
court only
am
grants
not.
under the Sixth Amendment, right? Under the Sixth Amendment, you have the grants
Okay,
the opportunity to tell them.
I'm only gonna fine you $50 for that first contempt.
$50 for what? What do I
For
understand?
continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me
I'm going to object. It's been asked and
jurisdiction it was.
answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday and move forward in the case.
Mr. Curvin, do you want a jury trial or a bench trial?
I want a jury trial.
Isaiah tries to claim he filed a special appearance motion. The court never received it. He says it was emailed. The judge says nothing arrived. He claims they acknowledged it. Before she says repeating a claim will not change the fact it is not on record. The reality is clear. Isaiah is trapped by his own lack of preparation. The court offers him yet another chance to get an attorney. If he cannot manage filings and procedure himself, he rejects the help, choosing instead to press on with his own failing strategy. The more he talks, the more it sounds like he is digging his own grave in front of everyone in the courtroom, and the clock is running out.
Missy, do we have tomorrow open? Let's see, we've got a 9 o'clock docket. What do we have going on tomorrow afternoon, Missy?
We have first appearances and I haven't looked at them yet. And then,
Okay, and then we have 3:30.
yeah, we have a couple at 3:30 and then we have a 4 o'clock case.
Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me
I
in.
think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have to-
11 o'clock is the perfect time for the state judge.
Well, but I've
So
got to
you
give
have to be
Mr.
in court
Curvin.
tomorrow?
I've
got a
got to give, sir, please quit interrupting. This is not a free for all. Miss Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot
present.
make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well, there's,
You told me you said Wednesday at first, and now you're saying tomorrow.
well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I
most
could do the
cases,
Zoom, but I would move to drive because this like where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like, or like probably 2, and I would like drive like just like 32, 14. That's like half the day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like
if you don't have a
I wouldn't.
license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, 'cause that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas, you violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
Well, I was told the
you're-
officer said he told me I can take care of it from Texas. I would have to come back to Kansas when I got the rest of the
I have
ticket.
always told you that the trial would be live. Don't be pulling that on
No,
me.
no, not you. I'm talking about the officer when I got the ticket when I first got it. I let him know like I was just coming through Kansas. Like you don't live here. He said it. She said normally it's stupid do video and stuff because it's like different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Miss Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Curvin,
say it again, man.
any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on
have you
file, and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
When I have
Thank
a
you,
question
Judge.
before we go, when you said like how to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email
Okay,
I sent it a few
sir.
times. Not like that was the only way.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can
No, they
apply,
told me
and I will appoint one.
they had received them before. That's why I was understanding. Like now you say you never received them. But you say you received them before, like the first time we appeared, and then I actually received. I haven't received them. I
Mr.
haven't called.
Irvin, just because you keep repeating something doesn't mean you're going to get a different result.
No, no, I haven't repeated. I'm asking like they never received it, but they told me they did. That's just
You keep
kind of
saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
okay. You have a good day, Your Honor.
Thank you, sir.
The hearing ends with a clear warning: be present in Kansas tomorrow with motions properly filed or face a warrant. Isaiah does not seem to grasp the seriousness of the situation. The judge has repeated the law over and over, yet he stands frozen in his script like he is reading from a sovereign citizen manual. Instead of addressing the real charges, the prosecutor shakes her head. The judge calls the next matter, and the courtroom moves on for now, but the outcome is inevitable. From the distance of Texas to the stubbornness on display, it is almost certain the next time anyone sees Isaiah will be in custody for failure to appear, and in that moment, his legal theories will mean nothing compared to the cold reality of a jail cell. So, if you want to see more chaos like this, hit that like button and subscribe, because we've got plenty more where this came from, and trust me, you won't want to miss the next one.